Good morning, everyone. This is Rajeshkumar. We are going to see one problem question on consideration today. Disclaimer: this video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. Let's move on to the problem question. The DD collects vintage cars, which she displays in a museum at her stately home. Her favorite car, a Bentley, in which her father won the lead man's 24-hour race, is stolen. D places an advertisement in the Times newspaper offering a reward of £100,000 to anyone who is able to return the car to her. We have to advise D on the following circumstances. Number one, a Nancy, a police inspector who is investigating the theft, locates the car and returns it and asks for the reward. Category two, Jessica, who is D's sister, stole the car as she disapproves of her sister's wealth. Jessica returned the car and asked for the reward which she wants to give to charity. Situation three is Pamela, a private investigator, is employed by D's insurance company to recover the car. She locates it and return it and asks for the reward. And the final one is Unity, sees the advertisements, spends several weeks locating the car, returns it, and claims the reward. However, she did not see the advertisement in the telegraph placed by D the day after the advertisement in the Times. So the first advertisement was in Telegraph newspaper. The second advertisement was in the Times newspaper. So she withdrawing in the Times newspaper, they withdraw the offer of a reward. Let's move on to the problem question analysis. This question mainly focus on unilateral contracts, consideration, and the intention to create the legal relationship, applying the contract law principles in several factual scenarios. The first let's move on to the first issue. The Nancy, a police officer investigating the car theft, he locates and returns the Bentley to D, and Nancy then seeks the reward. But the issue here is whether her performance of a pre-existing public duty can constitute a valid consideration of a D's promise. A principle that for performing an existing legal duty cannot be a good consideration is well established. In Collins versus Godfrey, in 1831, a witness suborned to attend court could not claim a compensation for fulfilling a legal obligation. Similarly, in Glassbrook Bros versus Glamorgan County Council in 1925 case, it was held that performing more than one's legal duty could constitute a good consideration, but simply doing what one is already bound to do is insufficient. So, applying this principle, Nancy is its duty as a police officer to investigate the crime, including the car theft, means that returning the car falls within her public duty. So, therefore, she cannot claim the reward based on the performance of the pre-existing legal obligation. In other words, Nancy, as a police officer, is obliged to investigate the crime, which include locating the stolen property. The principle that performing a pre-existing legal duty does not constitute a good consideration is highlighted in the Glassbrooks versus Glamorgan Country Council case. Since the general rule is that a performance of an existing public duty is not a good consideration, Nancy's could claim would likely fail unless she can show that her effort went beyond her legal duty, akin to Glassbrook Bros case, where the police provided extra protection beyond their normal duty. So, in conclusion, Nancy cannot claim the reward as her action merely fulfill her, her legal obligation. Let's analyze the instance number two, where the Jessica's D's sister steal the car and then returns it, requesting the reward to donate the charity. The issue has revolved around illegality and the nature of the claim and seeking a reward for returning the stolen good that took it in the first place. A fundamental rule of contract law is that a contract based on the illegal act is unenforceable. In Everest versus William case in 1725, the courts refused to enforce a contract between two highwaymen to share the stolen goods, as it involved the illegal contract. In Jessica's case, similarly, she cannot benefit from her own wrongdoing. Her claim is tainted by illegality, as she was the one who committed the theft. So, thus, any contractual claims she has is void. Similarly, the Jessica cannot claim the reward because of the principle that a person cannot benefit from their own wrongdoing. In Gray versus Barr case, the court confirmed that a person cannot recover a benefit, even the tort, from illegal or immoral acts. Similarly, Jessica's theft of the car negates her entitlement to the reward. Allowing Jessica to claim the reward would be against the public policy, as it would encourage individuals to commit crimes and then demand compensation for remedying the very wrong they caused. Jessica's act of returning car, while potentially beneficial to D, was done to correct her own illegal conduct. A public policy prevents the enforcement of the contract where it rewards illegal actions, making the promise to pay the reward unenforceable in her case. So, Jessica's request for the reward would fail on the grounds of illegality and public policy. Let's move on to the third instance. Pamela, the private investigator employed by D's insurance company to locate and return the car. She successfully does so and seek the reward. Here, the issue centers on pre-existing duties owed to a third party and whether such duties can constitute a good consideration. Third party duties, the principle that performing an existing duty to a third party can still constitute a valid consideration for the new promise, is supported by cases such as Scottson versus Peg in 1861 and Power on versus Love in Long in 1980 case. In these cases, it was held that performing a contractual obligation owed to a third party can benefit the promiser and thus constitute a good consideration. Pamela's pre-existing duty to the insurance company does not negate her ability to claim the reward from D. In this case, Pamela is performing her contractual obligation to the insurance company, but not directly to D, making her eligible of the reward. Since Pamela's contractual duty was owed to a third party, the insurance company, her performance could still constitute a consideration to D's unilateral offer. These advertisements suggest an intention to create a legal relationship with anyone who returns the car. The Pamela can claim the reward as a performance of the pre-existing duty owed to the insurance company does not preclude her from enforcing these unilateral offer. Therefore, despite the existence of a third-party contract, Pamela's performance can be a valid consideration for these promises. As such, Pamela is likely entitled to the reward. We came to the last one, the unity claim and the issue of revocation. Unity spends weeks locating, returning the car, but was unaware that D had withdrawn the reward by placing a revocation notice in a different newspaper. The issue here is whether the revocation of a unilateral offer was properly communicated to Unity. A unilateral offer can be revoked at any time before it is accepted, but the revocation must be effectively communicated. The principle is supported by Rutledge versus Grant in 1828, where the offerer could withdraw the offer before acceptance. In case of unilateral contracts like Bryan versus Van Tenhoven in 1880, held that revocation must be communicated, and Shui versus United States in 1875 clarified that a unilateral offer made by the public advertisement must be revoked in the same or similar manner as the original offer. The legal issue here is whether the unity can claim the reward despite the revocation. In Carlyle versus Carbolic Smokeball case in 1893, the court held that unilateral offers becomes binding once the offeree starts performing the act requested by the offerer. The unity's effort to locate the car would indicate her acceptance of this offer, assuming she was unaware of the revocation. In Bryan versus Van Theven case in 1880 establishes that revocation is only effective once communicated to the offeree. Moreover, in Shaw versus the US case in 1875, it was held that a revocation of a public offer must be made using the same or similar prominent method of communication as the original offer. While both the Times and Telegraph are newspapers, Unity only saw the original advertisement, raising the question of whether the revocation was communicated effectively. Since the Unity relied on the original advertisement in the Times, the court might find that revocation was not effectively communicated to her. Consequently, Unity could argue that she is entitled to the reward as the offer had not been validly revoked when she completed the task. If the court finds that the publication in the Telegraph is not equivalent to the original advertisement in the Times, D may be obliged to pay the reward. If the court finds that both newspaper and are equivalent means of communication, the unity's claim would fail. Let's conclude. In scenario A, then Nancy, the public officer, cannot claim the reward because the fulfilling her public duty does not constitute a good consideration. In scenario B, Jessica, having stolen the car herself, cannot claim the reward due to the principle of illegality. In scenario C, Pamela, the private investigator, can claim the reward since her performance of a pre existing duty owed to a third party constitute a good consideration. In scenario D, the unity claims hinges on whether the court deems the revocation in the Telegraph equal to the original offer in the Times. If not, Deborah may be liable to pay the reward. Thank you.